Attendees are in listen-only mode.
Good afternoon, and thank you for joining us for the webinar, Patents, Trademarks, and Copyrights, What You Need to Know. My name is Tim Tormone, Associate Executive Director of Alumni Engagement and Outreach at the University of Maryland Alumni Association. I'm pleased to introduce you to Jeff Karceski, a 1988 engineering graduate of the university. Excuse me. Jeff received his law degree in 1991 and has been practicing intellectual property law for the past 25 years and has created a comprehensive presentation for you today. A couple of quick housekeeping details. A recording of the presentation as well as the PowerPoint that you see today will be sent to you within 24 hours. Please feel free to ask any questions you have. We will try to get through as many as we can during the hour. Also, Jeff's contact information is at the end of the presentation in case you have additional questions after the presentation. So without further ado, please welcome Jeff Karceski.
Tim, and thank you very much. And for everybody who's online, thank you for attending. As Tim was saying, we're going to go through and do a review of intellectual property. But before I get started, let me go ahead and I'm having a little difficulty now. Here we go. Let me go ahead and put up my disclaimer, I guess. Being an attorney, I guess we all have to start there. And that is that the information that's presented in this presentation, you shouldn't rely on for legal advice, of course. If you have any questions, what you should do is go ahead and contact an attorney. And by all means, as Tim was indicating, my contact information is at the end of this presentation. So if you do have any questions or if you want to discuss any particular issues, I'm very happy to talk with you after we're finished with the presentation. What I'll do is, as we're going through the presentation, I will go ahead and have some pauses and breaks so that if anyone has any questions, we can go ahead and take questions as we finish each of the different topics. Tim's already done an introduction of me, but I had put a little bit of my background on the slide. And as Tim said, I am a graduate from the University of Maryland. Went to law school at GW. I'm currently teaching as an adjunct professor at Georgetown, and I am a registered patent attorney, and most of the work that I do on a day-to-day basis is in patent law, although I do touch on the other intellectual property areas that we're about to talk about. So for today, what I wanted to do was go through on a very high level patents, trademarks, and copyrights, which are the three areas that I think people have the greatest amount of interest. And I wanted to talk about, what are or how do you obtain these rights, how long do these rights last, and what do these rights actually mean, and then some additional issues that also come up that people have questions about, some things that people typically run into, some errors, maybe some misperceptions. So I'm going to try to touch on some of the things that have come up, and especially using a little bit of my experience with my teaching from Georgetown, some of the areas that I think people usually ask questions in each of the three areas of intellectual property we're going to talk about. Now, what I want to start with is just kind of like a really broad overview. So patents deal with inventions. We're going to talk about what that is in a few minutes. Trademarks deal with what we refer to as source identifiers. They identify the source of goods or services, and it can really be anything. We run into trademarks, obviously, in our daily lives for a lot of, in a lot of different ways, primarily as either words or graphical information, but it could be a whole lot of other things that identify the source of goods or services, like a jingle or a phrase. Copyrights are directed to works of authorship, which we will actually define when we get to that section of the presentation. Now, the one area that we're actually not going to talk about, which is the main reason for this slide, is we're not going to be talking about trade secrets today, but I did want to point out that trade secrets is a type of intellectual property that is available if you have information, if your company has information that's important for your company's business or for your operations that you want to keep secret. The law actually does protect that information so long as you keep it secret. But as I said, we're not going to be talking about that particular area of intellectual property for the remainder of this presentation. Now, this maybe kind of goes without saying, but intellectual property, just by its very name, is in fact property. And for that reason, it can be, bought, sold, transferred, licensed. You can leave a, intellectual property in a will to your heirs if you'd like. And of course, companies, buy and sell and transfer and license intellectual property on a regular basis. very much today part of the business environment. Again, what I want to do is, through the presentation, talk about how we procure these rights, how long they last, and the scope. So without ado, let's go ahead and get started with patent law. So patents, the basics. One of the first things that we need to say about patents is, in fact, there are 3 different types of patents that are available under United States law. Most people, when they think of patents, actually think of the first type, which are utility patents. And these encompass processes, machines, compositions of matter, and articles of manufacture. In the United States, we actually started numbering our patents, not exactly from 1, at least that's the urban legend, but for all intents and purposes, we started at 1. And today we're over 9,300,000. Design patents are a different type of patent. They deal with the ornamental appearance of something. We're not going to focus on design patents, or as it turns out, plant patents through the remainder of this discussion. But it's important to note that if you have something like, a good example of a design patent would be the appearance of a car, for example. Just the way that it looks, its actual exterior physical appearance, is something which you actually can protect by design patent law, separate and apart from any utilitarian aspects which would be protected by the first category. Plant patents are incredibly rare, as you can see just by the number that have issued. I'm not going to spend any time on this, but in fact you can actually protect a plant and its very specific qualities of the plant, but I'm not going to say anything further because typically that's not something that people have questions about. It's usually utility and design patents that are the primary categories that people are most interested in. With respect to patent law, in order to have rights in a patent, you actually have to go to the United States government, in particular the United States Patent Office, and ask for the Patent Office to grant to you rights for a particular invention. The way in which you do this is you file what's called a patent application, and that patent application is prosecuted, and the prosecution is the word that we use for the process by which we obtain patent rights. That application is prosecuted before the Patent Office, and if you're successful and you have an invention which is protectable, then the patent will grant. And it normally takes about 2 to 3 years, 24 to 36 months, from the time you file a patent application before a patent grants. So the process can be quite long. There are ways to accelerate it, but we're not going to talk about that today. This slide is just a couple of patents that I pulled that our firm has had recently issued. On the left is a utility patent, and on the right is a design patent. The only reason I put this slide in, and we'll do the same with trademarks and copyrights, is just so that you've seen what a patent looks like before if you actually haven't seen one before. In my years of teaching, it's actually surprising how few people have actually seen what an actual grant looks like for a patent. Now, the duration of a patent is different depending on the type of patent that is acquired. For a utility patent, the term of the patent is measured 20 years from the filing date, and the same is true for a plant patent. For a design patent, we measure the term from the issue date of the design patent. Currently, that term is for 15 years, although that all recently changed, so it could be 14 or 15 years, depending on when the patent issued. Now, a question that comes up frequently is, how do I know if I have something which is protectable? So what I wanted to do is just touch on a little bit of what makes an invention protectable. And in the United States anyway, we define patentability according to 3 criteria. The first is utility, which is really is a very broad requirement, which simply says that the invention that you are trying to protect is either not illegal, deceptive, or violates a law of science or physics, chemistry, whatever the case may be. 2 of the more important requirements is that the invention be novel and that it also be non-obvious. Non-obviousness is very broadly defined in this slide, and as you'll see with the slides throughout the presentation, they're at a very high level. But at any rate, non-obviousness is basically a definition of the advancement of a particular technology over what somebody of ordinary skill in the art would know. So having said that, what does this really mean? So from a practical standpoint, if I live in a world where we only have 2 pencils, okay, then a red pencil in that world is going to be new because it's something that never existed before. But the question of whether or not it's obvious is something that's a little bit harder to define, and there we actually looked at facts. So a simple example is if, for example, the red lead in my pencil already existed, and all I did was take the blue lead out and put the red lead into the pencil. Well, clearly that would be obvious and therefore would not be an advancement of the technology sufficient to have a patent granted to me for that particular invention. But if I change the facts even just a little bit, and I tell you that it took a team of 100 scientists 5 years in order to develop the red lead that goes into the pencil, well, then the outcome would be quite different. And there, the invention would not be obvious, and it would therefore be patentable. Now, in the United States today, we actually have what's referred to as a first inventor to file system. And the quick way of thinking about this is, if you've invented something, you want to get your patent application on file as quickly as possible because there are things that can occur that can prevent you from getting a patent. Now, you do have a grace period of a year for certain activities, but as we're going to see as we go through these slides, the best thing for any inventor to do, especially if this particular invention is important for your company or for yourself, is to go ahead and get an application on file as quickly as possible. This is especially true with respect to rights outside of the U.S. So what can happen is you can file a U.S. application, use that U.S. application to also obtain concurrent rights or equivalent rights in a foreign country. But foreign countries are actually more strict about their laws, and in foreign countries they have what's called an absolute novelty approach, which basically means that you have to file a patent application first before making any disclosures. Now in the U.S., just as I said a minute ago, you're not going to be able to get a patent if you've disclosed your invention or if your invention was described by another party in a patent. That makes sense, right? If somebody else has already described it in a patent or patent application, clearly they've done it first, so you can't get a patent. But if you disclose your invention, you may not be able to get a patent. And this goes to really the exceptions to the rule. Basically, you are allowed 1 year if you, the inventor, make the disclosure, or if you offer for sale your invention, to get a patent application on file in the U.S. Now, if you make a disclosure, you're probably not going to get a foreign patent, but you still have at least the option of getting a U.S. patent. Another thing that can occur is that if you tell somebody about your invention and then they disclose it, you might still be okay under U.S. law with respect to that disclosure. That's referred to as derivation, the second point on this slide. Now this slide, which is included in the presentation, I'm not going to spend any time on, but I just wanted to point it out. This is something that I pulled from the United States Patent and Trademark Office that basically gives an overview of what makes something, what the rule is for patentability and the exceptions. I'm not going to spend any time on this, but it is included in the PowerPoint materials in case you want to go back and refer to it later. Now, having said all of these things, as hopefully is really apparent, is that the most common errors that inventors make is that they make their disclosures to other parties or they try to sell their inventions to other parties before they file a patent application. And this can be problematic, and this can come up a lot of different ways. One of the things that does happen frequently is that inventors will go to, for example, a convention, and they'll want to make a presentation about this great idea that they have. Well, of course, that's a disclosure, and that disclosure can potentially be problematic for your obtaining a patent at a later time. Or another thing which can occur is that a company can go to, like a convention where, it might be like a product convention where you're actually showcasing your products to other companies and to potential customers. That also can be potentially a problem for obtaining a patent later because that could be a offer for sale or a disclosure as well. Now, as I said, if you make any disclosures, this will definitely be a problem with respect to foreign patent protection, or I shouldn't say definitely, it's very likely will be a problem, simply because they have the absolute novelty approach. So, of course, having said all of this, the best thing to do is to go ahead and try to get a patent application on file before you make a disclosure or before you offer your invention for sale to another party. That way you can create the least amount of problems for yourself if you decide you want to go ahead and protect your rights at a later date. Now, of course, once we get a patent, what does this mean? Well, when you have a patent granted to you, the patent actually gives you rights to prevent others from making, using, selling, offering to sell, or importing the invention that you have patented to you. And these rights are actually quite broad. And even more specifically, what they do is they prevent somebody, so if you have these rights as a patent, you can prevent somebody from engaging in what we call literal infringement, making an exact copy of what it is you protected, but the law also is actually a little bit broader than that. It can protect you or give you the ability to prevent others from making an invention which is what we call insubstantially different, or maybe more of a common way of looking at it would be just making some minor changes to the invention and then putting it on the market. So you can prevent others from not only doing what it is that you protected, but also some variations on what you protected, as long as those variations are not all that great. Of course, the flip side is that if you are a company, you can run into the same problem, because you can also be infringing someone else's patents, either literally or by doing something which is a minor variant on something that they've protected under the law. Which leads us to some points that I wanted to bring up, the first of which is that the mere fact that you're not aware of somebody else's patent is not going to be an excuse for infringement. The law is set up such that if you infringe someone's patent, whether it's an exact copy or something which is very similar, you are liable for infringement, even though you're not aware that the other party has a patent. And it's even worse if you know about the patent and yet you engage in that conduct anyway, because if you willfully infringe a patent, you can be liable for up to 3 times the damages that you would otherwise be liable for just for regular patent infringement, if you will. So that actually covers the basics for patent law, and I realize we've gone through very quickly the subject matter. So what I wanted to do was actually take a pause real quick and ask Tim if there were any questions about what we've gone over so far before we actually talk about trademark law.
Hi, Jeff. At this point, I don't have any questions that people are asking, so it's a good reminder that on your screen you should see a space where you can go in and type a question for Jeff, and if you have one, please do so we can get that answered for you. But as of the moment, we don't have any questions.
Okay, perfect. All right, well then we'll go ahead and move our way into trademark law. And we're basically going to do the same with trademark law as we just did with patents, which is to go over, of course, how you procure trademark rights, the duration of those rights, and then some aspects associated with those rights being the scope of the protection of those rights. So the first thing, trademarks, when we talk about trademarks, we're actually talking about a group of 4 different marks under United States trademark law. Now the first 2 that are on the screen are trademarks and service marks. Trademarks, strictly defined, are the identifiers for products, so goods. And the example that I've used on the screen is Apple for electronic products. Service marks are marks that are associated with services. Now there are 2 other types of marks that we're not going to go into today, but I just want to mention them briefly. The first is called the certification mark, and these marks are the type of marks that you would find for, in particular for certification of, the quality of goods or services. There are lots of them. I used Idaho potatoes as my example, but like AAA is another example. Underwriter Laboratories is a further example, and there are quite a few that we run into on a regular basis, like the Real Seal for dairy products is another example, or kosher. The kosher seal is actually another one as well. Collected marks is a separate category of marks by itself that signifies membership or indicates membership in a particular organization. The ABA is an example, at least the American Bar Association is an example of one type of collective mark, but the NFL is also one which I've included on the screen. Now we're not going to focus on certification marks and collective marks, but just recognize that these are 2 types of marks that also are protectable under federal law. And when we talk about trademarks and service marks, I just want to say, a lot of times when people use the word trademark, they are in fact using it whether they're referring to a trademark or whether they're referring to a service mark. So what I'm going to do is I fall into that category, and so when I use the word trademark, I may be using it in terms of trademark, or in terms of service mark, I'm using that kind of generically to cover both. So the basics, how do we procure rights? Well, as it turns out, trademark law has 2 parts to it. There is the common law part, and there's also the federal law part. So what we need to do is start with the common law part. And under the common law, you establish rights in a particular trademark simply by using the marks on goods or services in a particular geographic region. And the way that the law is set up, and this has been true since I believe it's the 1800s at the very least, may even be longer, is that simply by using the mark on the goods or services, you are establishing rights in those marks. And those rights are good for the geographic region in which you use the mark. So, a simple example would be the following. Let's say we were to go ahead and create our company. We're going to call it Acme, so I'll just go ahead and use, something very generic. We're going to be the Acme company. We start applying Acme to a product that we create. Let's say it's, I don't know, we'll make it a pen, for example, since I'm looking at a pen on my desk. They're Acme pens. Once we start applying Acme to the pens that we are selling, we have established use, and so therefore we have established rights simply because we have introduced our trademark into the stream of commerce. You don't need to actually do anything to establish the rights. You don't need to try to register rights under the common law. There's no such thing. As I said, use of the trademark is simply enough. Under federal law, it's a little bit different. Under federal law, you actually do need to, if you would like to have rights protected, you do need actually to file an application to procure federal rights under what we call the Lanham Act, which is the existing law for trademark law. And I see from Tim that we actually had some questions under patent law, so what I'll do is I'll take a break and we can actually address those questions in just a second before we go on with trademark, but let me go ahead and finish up my discussion on the slide. So at any rate, in order to acquire federal trademark rights, you need to file an application, and it takes 12 to 24 months. So let me start there and ask Tim the questions that we had under patent law before I go on with trademarks.
Yeah, sorry everyone. I must have had a bit of a computer glitch because I got about 8 questions coming in all at once. First question, what were the 2 reasons a patent could be barred for? That's from Nikki.
The first one is, absolutely, so it can be barred if you make a disclosure, and it can be barred if you offer your invention to sale. There are additional ones, but those are the 2 primary ones.
Okay, this question's from Nathan. If an inventor's name is left out, is the patent application valid?
So if an inventor's name is left out, then by definition, the application is not valid, and any patent granting from that particular application is not valid. However, inventorship can be changed, and there are procedures for changing inventorship and adding an inventor if they were inadvertently left off of a particular application. There's a whole area of the law that addresses that particular question.
Great. The next question is about the PowerPoint, and the answer is yes. Everyone will receive a copy of the PowerPoint and a recording of this particular presentation within 24 hours of the event today. So FYI. This is from, it looks like Jimmy. How long does the patent research normally take and cost?
Absolutely. Well, first of all, Jimmy, you are not required to do any patent searching before you file a patent application. You can, if you would like, go ahead and file an application, but of course the cost of filing an application can be quite high depending on the technology and how complex the invention is, so it's always a good idea to do a search. What I normally find is that most searches are probably going to cost somewhere between, I would say, $2,000 to $3,000, $2,000 to $4,000, just as a general rule of thumb. But of course it all depends on how thorough you want the search to be and how much money you want to spend in searching. I have had some searches that have been considerably more expensive simply because the client wanted to be much more thorough and have a much greater understanding of what the prior art has.
Great. Onayo, I apologize if I pronounced that wrong, says, can you please explain the blue and red pencil example again? Thank you.
Sure, of course. Let me go back up to my blue and red pencil real quick. And the idea is that in order for something to be protected under patent law, it has to be new and non-obvious. New simply means that it hasn't been done before. So if I live in a world where we have only blue pencils, a red pencil is new, and so it satisfies the first requirement. That means that the invention is novel and it would be patentable. But the other requirement is that it is non-obvious. And non-obvious means that it has to be a sufficient advancement in the technology that it would not be something that one of ordinary skill in the art would think to make. And the easiest way to talk about what is non-obvious, at least in my view, a simple way of looking at it is to look at it from the perspective of, in a way, how much effort went into the development of that particular technology. Because if it's something where, as I said, if all I did was I just took the the red lead actually existed already, and all I did was remove the red lead from the pencil, the blue lead from the existing pencil and put the red lead in. I haven't done anything which is an advancement in technology, and so that would be obvious and therefore would not be patentable. However, if it took a team of scientists, 100 scientists, 5 years in order to develop the red lead to put in the pencil, well, clearly that would no longer be obvious. That would, in fact, be an advancement of the technology, and therefore it would be something which is protectable under the law.
Great. The rest of the questions are regarding patents. Do you want to wait till you get to the end of this section, or do you want to take them now?
No, we can go ahead and do it now before we move on with trademarks. I'm okay with that.
What is the best way to search for whether you are infringing on a patent?
Well, the best way to search, of course, is to look at the United States Patent and Trademark Office and the patents that are available there, because I'm assuming the question has to do with U.S. law. If you are asking whether or not you're infringing a patent in another country, then you would be, it would be necessary for you to do the equivalent research in that particular country, or, in the case of Europe, for example, there's a European Patent Office which covers multiple countries at once.
Bernard asks, can patents be renewed after 20 years?
They cannot. However, you can always file a new patent application for an improvement on an existing technology or a technology that you've already patented, so long as that improvement also meets the requirements that it be new and non-obvious.
Okay. Kara asks, will you be talking about international patents?
I'm not going to get a chance to talk about international patents. However, when we get to the end of the presentation, if there's a specific question that you have about international patents, I'm happy to go ahead and address it at that time.
Okay. Jorge asks, how can patents protect processes, and how can that be enforced?
Well, a process is simply a type of invention, and a process is defined very simply as a group of steps that are arranged in a particular order to achieve a particular result. So my simple example of a patent process is going to be, and I'm not a baker, but I'm going to use baking as an example. And I'm going to be baking cookies, right? So my process might be, mix the ingredients. I don't know what goes into cookies. I guess you need, flour and sugar and milk, and I'm not sure what else you would need. I don't know, eggs, I guess. Mix in a bowl, right? And then maybe the next step would be to cook. So you would need to, bake them at, 5,000 degrees for 2.5 microseconds. And then enjoy, right? Maybe that's my process, right? Something very, very simple. That can be protected so long as it meets the requirements of patentability. But if those steps are both new and non-obvious, well, it is protectable under the law just like any other type of invention. Now, the way you would enforce that particular patent would be you would have to know details of the process that somebody else is using. And if that process that the other party is using is identically the same as the process that you have protected, well then of course that would be literal infringement and you could sue for patent infringement. Same would be true even if they had made a slight variation on your process. So in my process I needed to cook at 5 million degrees for 2.5 microseconds, right? So maybe somebody is going to cook them at, I don't know, 4,999,000 degrees, right? So they're off by 1 degree. That in my mind, just based on my quick definition, is just a slight variation, and so that also would be an infringement of my patent.
All right. Remind me never to accept any baked goods from you, Jeff. And Jimmy has a question, what is the typical timeline for patent approval once a patent application has been filed?
Yes, as I said, it typically takes 24 to 36 months or 2 to 3 years. However, there are ways in which you can accelerate that process by paying additional fees or making an additional submission.
Okay. Joseph asks, and I think you may have answered this, but just in case you didn't, how does one go about looking up, searching patents and trademarks and determining if similar or identical things are out there?
Again, the easiest way to do that is to go to the United States Patent and Trademark Office, and you can run a Boolean search through their website for both patents and trademarks, and you can make an evaluation as to whether or not they exist. There are additional searching services that are available worldwide, but the United States Patent and Trademark Office is the primary one, and we haven't gotten there yet, but the next to last slide, or my penultimate slide, I guess, in this presentation actually includes the United States Patent Office website address so that you can actually refer to it if you want to go ahead and do a search.
Okay. Do you need to use an attorney for filing a patent?
You do not need to have an attorney to file for a patent application. However, it is very highly recommended because the process is fairly complicated, and having someone who's familiar with the process is going to make the process go much more smoothly than if you try to do it yourself. However, as an individual, you are permitted to do that.
Okay. What is a provisional patent, and what is its relevance to what you are presenting or what you've presented already?
Okay, that's I had thought about putting that in the presentation, but it's an excellent question. A provisional patent application is one that, in its very broad definition, is what we like to refer to as an informal application. An application that is provisional is one that doesn't have all of the formal requirements of an application that is examined. And for that reason, a provisional application is not examined. What happens is that provisional applications, one reason for filing a provisional is that, let's say you are coming up to a disclosure. Let's say you're about to go to a trade show. Your trade show, as it turns out, is this Friday. Tomorrow, in fact. Let's even make it even quicker. And you are concerned about making a disclosure because, as we were talking about a moment ago, a disclosure potentially could prevent you from getting a patent at a future date. You'd like to get a patent application on file, but you don't have a lot of time to put a lot of effort into it. What you can do is you could spend, the rest of the day today and the rest of the day tomorrow to put together a description of your invention, and then you could file it as a provisional application. And what that does is it establishes a filing date for your invention, but it's not something that the patent office is going to examine. The provisional application is good for a year, so for all intents and purposes, it gives you a year to hire an attorney to prepare the formal version of the application, or if you're going to do it yourself, to prepare that formal application on your own.
Great. We're going to do one more, and then I'll get
Sure.
you back on to your presentation. Regina asks, I have a material design change for something that has already been created and sold. Can I just change the design and it not be considered infringement?
That's an impossible question to answer on the phone. The short answer is probably not, but it all depends on what the rights are that were acquired by the other party. Because what happens is that potentially you have the problem when you're making a modification of design, is that simply because you modify it does not mean that you're avoiding infringement of the original patent. You may be able to get a patent on your own for the improvement, but you may still be infringing the patent that the other party may have. So it's a little bit more of a complicated question, and maybe what I'd like to do is leave that until the very end. If we have some additional time, we can revisit that question and talk about it further.
Great, thank you.
All right, so let's go ahead and move on to the next slide for trademark law. And what I wanted to do, I pulled this actually because this is a company that was founded by a University of Maryland graduate, and that's Under Armour, just to show you what a registration under federal law looks like if you do actually obtain one. So that's this next slide. Now, trademark rights, potentially under common law or even under federal law, potentially are unlimited. So long as under the common law you're using the trademark, you have protection under the law. Under federal law, when you obtain a registration like the one we just had, the Under Armour registration, that registration is good for a period of 10 years, but you can renew that registration in 10-year increments. And as long as, you continue to use the trademark, you can have protection for that trademark. And I think I should have said when I was looking at this previous slide, just to make sure that I touch on this, one of the important aspects of federal trademark law is that in order for you to protect a law under the Lanham, or protect a trademark rather under the Lanham Act, you need to have interstate commerce, meaning that your trademark has to be actually has to have been applied to goods or services that are crossing state lines or are in international commerce. That's the way that that can come up. Now, when you receive rights under trademark law in particular, both common law and federal law, what you may do is prevent the subsequent user who is using a mark that is either similar or the same mark from using that mark on similar goods and services. So there are two aspects that are important with respect to trademark law, and that is that the mark is important, and also the goods or services that the mark is being applied to are also important. And that's really the definition, basic definition of trademark infringement. So the rule here is, I'm not going to go through all of this slide in incredible detail. We can come back to this if you would like. But the simple way of looking at this is, it is actually in fact possible, and you, I'm sure, have run into this circumstance where there could be either the same mark or a similar mark that's being used on dissimilar goods, very different goods. The one that I think of immediately when I think of this particular category is that hopefully everybody is aware of Champion, which is a trademark for athletic gear, sweatshirts, sweatpants. But there's also a Champion trademark that's applied to spark plugs. So we have Champion spark plugs and Champion athletic gear. Those are not the same company, but of course it is identically the same trademark, but it's being used on different goods, and that is totally permitted under the law. Now there is also another category under trademark law which is considered fair use. So there are two simple examples. So it is possible that you could use somebody else's trademarks on very, very limited circumstances. One is for advertising. So if I make soft scrub, which hopefully everybody is familiar with, it's a liquid cleanser, and I advertise that my soft scrub has Clorox bleach, I can use the trademark Clorox even though it's not mine, so long as in fact I'm putting Clorox bleach in my soft scrub. I can't just buy generic bleach and put it in my soft scrub and say it's Clorox bleach. It must in fact be the product that is branded by another company. Another example where trademark use of another company's trademark is fair is in comparative statements such as if McDonald's says McDonald's fries are better than Burger King's fries, but as a general rule you're going to need to have some survey evidence that's going to be supportive of the comparative statement that you make. Now there are lots of issues and questions that people have, I think, with respect to trademarks that come up quite frequently. And the first thing that I want to say is the basic rule is don't use somebody else's trademark. Right? That should be fairly self-evident, but truly and honestly stay away from the use of somebody else's trademarks, because even though we do have the possibility of fair use, the best thing to do is that unless you are certain that your use is fair and is going to be permitted, the best thing to do is to not engage in using someone else's trademarks, because you could run afoul of trademark law and create liability for yourself. Something else that's important to note is that trivial changes of another party's trademark is not typically going to be enough to avoid infringement. So if you're going to adopt a trademark, you want to make sure that it's going to be very different from somebody else, or separately that the goods that you're applying the trademark to are quite different. Something else that's really more just kind of a practical thing to keep in mind is that when you're thinking about introducing goods or services into commerce, think about what your trademark is going to be early in the development of your goods or services. And the reason I say that is because oftentimes people think of trademarks almost as an afterthought, and they come up with a trademark that they really think is really exciting and very good. Then they actually look to see what other people are using. They find out that the mark maybe really is something that someone else is using, or maybe it's not as good as they think. That can be a little bit of a a bruise to somebody's ego, maybe a little bit deflating. So the point here is simply think about what kind of trademarks you might want to use. Do your research early so that you know that the trademark is available, so you don't get surprised when you actually introduce the trademark into commerce, only to find out later that the trademark is something that's not going to be available to you because it's a problem with somebody else's mark. Also, use the trademark as a source identifier. Use it as it's supposed to be used, meaning use the mark on the goods or services, and put it in your promotional materials. It's not just an afterthought. A trademark is simply not something that you came up with. You actually have to use it. So actually apply it to your goods and services and make people aware that this is your trademark and it's something that you're asserting as your property. And the last thing that I wanted to point out is that make sure before you register a trademark federally or try to do so that you're using the trademark in interstate commerce. There is an exception. You can actually try to apply for an application or apply for trademark protection before you use a trademark in interstate commerce. That's a whole separate area. So I've just made a notation on this slide we're not going to get into intent to use applications for trademark protection. One other thing I want to say before we close out of trademark law is that a trade name, meaning a company name, is not a trademark. In order for something to be a trademark, it has to be used as a source identifier. It has to be used on goods or services. This happens very frequently where people will come to me and they'll say, hey, I've got a great name for a company, I'd like to trademark it. Well, immediately we have a problem, because if it's just a company name, it's not being used as a trademark, and so is not protectable under the law. And second, we can't protect that mark until you're using it on goods or services in interstate commerce. At least not protected federally, although there may be some common law protection once you're applying it to goods in a particular geographic area, goods or services, that is. Well, that's a quick overview of trademark law, so let me go ahead and take a break now before we go into copyright law and see, Tim, if there are any questions on trademark law.
Yeah, we have a few more questions here.
Sure.
Kara asks, is your invention protected when the patent is pending? Can you disclose to others that you have a pending patent?
Okay, so we're going back to patent law, totally fine. And the short answer is you do not have any patent rights. You do not have any protection while your patent application is pending. You may, of course, disclose your invention to other parties because, of course, you have a patent application pending. The only caution that I would have there is before you make a disclosure, you want to make sure that you are not going to go outside of the disclosure of your patent application, meaning don't describe something in addition to what you have in your application, especially if that additional subject matter is something that you would also like to seek protection for, because that might be, the additional material might be, for example, associated with an improvement that you're thinking that you might want to protect later, so that might be something you may want to keep quiet until you've gotten another application on file.
Elizabeth asks, regarding patents, the non-obvious rule, how dependent is this decision on the patent reviewer?
That's an excellent question, and the person, the patent examiner who is looking at the application, can have a different view on the question of non-obviousness based on their own experience and the amount of time that they've been involved in patent law. So it can make a difference in terms of who the person is who is making that determination. That's a very complicated question, but let me simply say if you are in front of an examiner who is very strongly making the argument that your invention is not protectable because it is obvious and you believe otherwise, it is possible that you can appeal that examiner's decision within the patent office, and that might be actually one avenue that you have available to you. But maybe that's a question that's probably better left for an offline discussion if you'd like to talk about it more.
Kara asks, is there any way to circumvent a patent?
There's no way to circumvent a patent, but of course you can have products that do not infringe a patent, because the way in which you infringe is by either doing what the patent tells you not to do or something similar, right, and substantially different. So in order to not infringe, right, so we don't try to avoid a patent. What we say is you want to develop your products so that they are non-infringing. So what you would do is you would include elements in your product that are not part of the patent and thereby avoid infringement in its entirety. Again, this is an area of the law which is very complex, so that's a very broad way of looking at it, and that's also something that's probably left for an offline discussion separately if you still have further questions.
Okay, Regina asks a really interesting question. Because you used a baking process as an example, and she probably doesn't want your baking either, she asks, can a medical procedure be patented?
And in fact, a medical procedure can. There are, as it turns out, there are some foreign countries which do not permit the patenting of a medical procedure, but medical procedures are patentable in the United States.
Great. And it looks like the rest of the questions, let's go to copyright law and finish up with the rest of the questions. I think it's a good break right here.
Perfect. Well, copyright law, of course, changing gears, is going to cover something which is quite different. And when we look at what is protectable under copyright law, we're looking at something which is called a work of authorship. We'll get to that momentarily. It needs to be fixed in tangible form, and it needs to be something original, which means that it has not been copied. Now, the two photographs that I have on this slide are simply to make a point. It is possible for one person or two different persons, photographer 1 and photographer 2, to take a picture and take, in fact, identically the same picture because they are standing at the same location. They can, in fact, have original works that are both separately independently protectable under copyright law because they have both created the same work. They have done it independently of one another. And so, therefore, it's a work of authorship. It's a photograph that's fixed in tangible form and, in fact, is original to each of the individual photographers because they have not copied the photograph one from the other. Works of authorship are listed on this particular slide, but they're all of the types of things that we would normally think of, like writings, movies, drama, choreographies, architecture, art, those kinds of things. And there are others, of course. Now, in order to protect rights under copyright law, the first thing that you should be aware of is that copyright law as it exists today gives you protection for your work of authorship from the moment that you create it. You're not required to register the work with the Copyright Office to have protection under copyright law. However, if you want to sue someone for copyright infringement and recover, damages or seek an injunction, you will be required to register the copyright. Having said that, of course, it's always a good idea if you have something which is important to you to go ahead and register it with the Copyright Office, but you are not required to do so in order to have rights protectable under the law, and by not registering the work, you are not going to lose any copyright that you might have. Now, in order to register your rights with the Copyright Office, it's really simple. All you do is basically fill out a form, pay the fee. The Copyright Office does not do any substantive examination of your application. So, as you can probably appreciate, the Copyright Office literally receives hundreds of thousands of submissions, maybe millions of submissions every year. It would be impossible for them to make a determination as to whether or not the subject matter is copyrightable or entirely new, not a copy of something which somebody else has done. So they don't actually do that. If there's a dispute as to whether or not you, in fact, the work is original to you, then what happens is that dispute actually is raised in litigation when you sue for the infringement of your rights. This next slide is simply just an example of a copyright registration line that I thought might be helpful, just so that you've actually seen what a registration looks like. The duration of rights under copyright law for the United States are actually quite long. And there are two particular durations, two particular terms that are important. The first is that if you register a work or have a work protected under the law, I shouldn't say registered, but once you create a work, if it's created by you, the author, then the duration of that work is your lifetime plus 70 years after you expire. If the work is created, if you're an employee of a company, for example, it's a work made for hire, we can't measure the term based on the lifetime of the company, so what we do is we measure it differently. We measure it 95 years from the date that the work is published, or 120 years from the date of creation of that work, whichever is shorter. Now, under copyright law, the rights that you have are to prevent others from doing a number of different things. And the first one is the most important one, I think, or the one most people think about, is it prevents somebody else from reproducing your work or making basically a photocopy of the work. That's one way of looking at it. But there are additional rights that are available to you under copyright law. You can prevent somebody else from performing your work, for example. And if your work is, for example, a musical work, that might be actually a right that is quite important to you. Now, in order to infringe a copyright, so the scope of your rights, there are two things that are important. For somebody to infringe your rights, they have to have had access to your work, and they have to create something which is substantially similar to what it is that you have protected under copyright law. And access is extraordinarily important, right? So this goes back to the idea that two parties can create the same work independently from one another. But if the other party didn't have access to your work, then they cannot be found to have infringed your work. Because again, the whole point of copyright law is to prevent someone else from making a copy. Now, access, of course, can be inferred. So there are lots of rules that go along with access. I'm not going to spend a lot of time on that, but it's important to keep in mind that these are the two basic requirements for infringing a copyright. What I really want to talk about is what makes or what uses are considered fair, because there's a whole area under copyright law called fair use. A lot of people use fair use in their everyday conversations, and they think they know what it means, but actually it's something quite specific and it's quite narrow. And one thing to keep in mind is that if you're talking about fair use, you are talking, or you by definition are of the understanding that you are infringing somebody else's work, or that you copied somebody else's work, because you're trying to come up with a defense for infringement, and that defense is fair use. When we're talking about fair use, there are several factors that we look at. We look at whether or not the work, or the nature of the work, is it fictional versus non-fictional. And the idea here is that if it's non-fictional, or tends to be non-fictional, like facts, that's not going to be protected under copyright law, or we're going to actually have something which is going to be the use of that, or copying of that factual information is going to be considered fair rather than not fair. We also look to the commercial nature of the work, or the purpose and character of the use. And if the reason that you are using the other party's material is for commercial purposes, then it's not going to be fair. But if it's for non-commercial purposes, then it will be. We also look to the amount of the work that's been copied. The less you take, the better off you are. And also we look to the economic impact of what you've done, its impact on the other party's copyright. So if you've had very little impact, then that's going to be considered fair. What does that mean? Well, what I did was I just created an example that makes it super easy, right? So like I've written a paper on fungus for one of my classes at school, right? That makes it super easy. Well, the work, or the nature of my work, my paper is non-fictional, right? That clearly falls into the idea of being fair. It's totally non-commercial. It's for educational purposes. There again, very fair. I've just taken a quotation from a scientific source. It's not the entire portion. It's a small portion, so therefore, again, that supports fair use. And I have had zero impact on the copyright associated with the original scientific article. And so therefore, looking at my 4 factors, my writing of my paper where I've quoted a scientific article would be considered to be fair under copyright law. Now, this is an incredibly complicated area of the law. So all I want to say is don't automatically assume that what you're doing is fair. You really do want to take a look at why you're using that particular work if it is not something that you've independently created entirely on your own. Now, one of the things, or many of the things I should say that come up, is that innocent copyright or innocent infringement is not a defense. You can't just say, well, I didn't know that I was copying somebody else's work. That doesn't work. There is no such thing as an innocent copying. You can't defend yourself by saying that everybody else is copying. Right? That's not a defense. Just because everybody's engaged in improper behavior doesn't mean that your behavior is excused. Also, just because something is on the internet doesn't mean that it's free for you to copy. That is not going to be the case, because as we were saying a minute ago, all I have to do is have access to the information and provide a substantially similar copy. That by itself is infringement. So downloading things from the internet is in fact copyright infringement. The mere fact that you've only copied a little bit of somebody else's work is typically not going to be a defense, although this does dovetail with what I was just saying a moment ago about fair use. And recharacterizing something in your own words or changing it, again, is not going to be a defense, because making something which is substantially similar to the original also is an infringement, even though it is a variation of what was originally, or what is originally protected under copyright law. There is also something else that's very important for people to be aware of under copyright law, and that's called vicarious infringement. It is possible that your company, if you're working for a company, could be liable for the infringement that's been done by its employees. Because if your employees are copying things, let's say from the internet, for example, and you do not have a policy with respect to what is considered fair use or how they should be paying for, downloading things from the internet, for example, then the company could be liable for vicarious infringement. This, again, is a very complex area of the law, but I want people to be aware of it, because oftentimes companies say, well, I'm not responsible for what my employees do. I, myself, the company, have not done it. But that may or may not be the case, and so you should be at least aware of that. Now, as I said, when we first started the discussion, I wanted to go ahead and provide some resources. So if you want to try to find anything with respect to patents and trademarks, go to the U.S. Patent and Trademark Office. That's at uspto.gov. And if you're interested in finding anything about copyright law, then you can go to www.copyright.gov, and that's the United States Copyright Office. So that now brings us to the conclusion of our discussion, with about 5 minutes, I think, left for some further questions. So let me go ahead and turn myself back to Tim for further questions. And of course, if anyone has any further questions that they want to add that Tim doesn't have, by all means, now's a good time.
All right, we have a fair amount of questions to get through in a short amount of time. So we'll try to do as much as we can. We may go over a few minutes. If you can stay on the line, that's great. But here we go. How much is the fee to submit an application with the Copyright Office?
Okay, it depends on whether or not you do it electronically or not electronically. If I remember correctly, to submit an electronic application at the Copyright Office, the current fee is $35. I could be wrong. It might be off by $5, $10 or something. It may have changed, but I believe that's correct.
Okay. Jorge asks, why register for a copyright if it's not required?
Because, well, there are a couple of reasons. One, the registration could be beneficial to your company because, going back to the very beginning of the presentation, copyrights are property rights. So one way to, keep record of all of your property rights as a company would be to go ahead and register at least the things that are important for your company, and then keep them as part of your property, right? So that would be one reason to do that. And of course, as I said before, if you want to sue to recover damages for copyright infringement, you are going to be required to register at that time, so that would be another reason to register as well. And I should say there are some additional reasons for doing so. For example, statutory damages are available, and there is actually a time limit for registering a copyright from the publication date. I believe it's 3 months from the publication date if you want to rely on statutory damages, but I think I just maybe derailed this train from its track, so let me go ahead and go to the next question.
Okay. Dior asks, I submitted the artwork in my logo for copyright. Am I protected federally?
Yes, copyright protection is federal protection. But when you say you've submitted your logo for copyright protection, please keep in mind that if you're conflating copyright law and trademark law together, so you will have protection under copyright law for the design that you created. However, you do not have federal protection under the Lanham Act for under trademark law for that logo, unless and until you actually seek protection under the Lanham Act and actually file a trademark application and are granted a registration for that logo.
Okay. Regarding fair use, I have a DVD of if I have a DVD of a movie or a copy of a video game, what rights do I have regarding use of that DVD or game? Could I put it on a website and give access to a friend?
It's an excellent question. The short answer is no. You are not permitted to do anything. If you purchase a copy of a DVD, the reason the sole and exclusive use that you have of that DVD is simply to play that DVD back for yourself, for your own enjoyment. Now, of course, that does extend to you can be playing it back for more than yourself. You could have other people in the room. It doesn't have to just be for you as an individual who purchased the DVD. However, placing a copy of the DVD on the internet for access to other parties does present a problem because that is in fact an infringement. There may be a reason why that might be excusable under fair use, so this kind of runs into a much more complex question, but the short answer to your question is no, you're not permitted to put it on the internet for other people to access.
Lawan asks, how long does it take the copyright application to be processed?
That's actually fairly quick. It just takes a few months in order for the application to be processed and for the registration to come back because it's all done electronically. To be honest, I had meant to look that up to see what the statistics were from the Copyright Office. I didn't do that before the presentation today for it, so I do apologize for that. My understanding is that it can take usually between 3 to 9 months depending on the backlog of the Copyright Office.
Okay. Another fair use question. I want to draw portraits of people for money and they want me to draw their favorite superhero character in it, or say they want to make a sculpture of the same. Does the use of these trademarked characters' artworks constitute infringement?
Okay, the short answer is yes, it does. And again, so you're conflating two things together, trademark and copyright law, and in fact it is a violation of both when you're using a superhero that is a recognized trademark and also protected copyright material of another company. So by incorporating a superhero into artwork, you are in fact both infringing not only the copyright but also the trademark in that particular work. You should be receiving, or you should technically ask for permission from the other party that owns that particular material. You should ask for their permission in order to incorporate that into your artwork. So I'll just leave it there, but if there's some additional questions, probably the best thing to do would be for us to talk about this offline because it's also a fairly complicated area of the law.
Okay. Macarena asks, what are the best ways for a photographer to protect her work?
Well, again, because it's photography, the short answer is that you do have protection under copyright law simply having taken the photographs. Immediately at the time you take the photographs, there is protection under copyright law. If these particular photographs, though, are ones that are very important to your company because they're specific assets that you would like to have protection for and possibly have the registration for, then the best thing to do is to create a compilation or a group of your photographs together and register those photographs as a group with the Copyright Office. But if you'd like, of course, you can register them individually. The reason I say it probably is a good idea to do them as a group is that way you can have multiple things that are registered simultaneously as a group of photographs and only have to pay one fee rather than pay the $35 for each registration that you make for each individual photograph. But that really is up to the individual or the company for making that determination as to how they would like to protect those rights.
Okay. Martin asks, how many works can you submit all at once to the Copyright Office?
Well, if it's a grouping of photographs, for example, there's no limit to the number that you submit all at once. So theoretically, you could submit, a very, very large number. Realistically, obviously, people do tend to divide things down into whatever would be a suitable number for their own, for their own record-keeping purposes, rather than making a global submission. But you can actually look at the Copyright Office in terms of what the rules are for those submissions.
I think as a follow-up question, Jean asks, what about sharing ebooks with friends? I think that was based on another question, actually.
It is. So the general rule is that sharing in and of itself is a distribution of a work, and so therefore is a violation of copyright law. Anytime you are sharing, especially electronic information with another party, that potentially is problematic. This is, again, not necessarily a straightforward answer. So what I'll do is let me use a book as an example, like a physical copy of a book that maybe makes things a little bit better. You can obviously share a physical copy of a book with another person. That's entirely fine. That's not a violation of copyright law. If, however, you were to make a copy and retain a copy for yourself, then that would be a violation. So with respect to electronic copies, we run into a similar difficulty. If you are, in fact, transferring your only copy of that work, the electronic copy, to another person, that is going to be probably fine, right, because you are not retaining a copy for yourself. However, if you were sharing, meaning that you were giving them a copy, then that would be a violation of copyright law.
Okay.
So again, maybe a little bit more complicated answer than you might have expected, and we can certainly talk about that offline separately.
Jeff, we've got about 7 questions left. Are you ready for them?
Sure, go for it.
As an author of non-fiction technical papers, may I cite my own prior work at length, or might that trigger an infringement claim from the original publisher? Obviously, as the original author, I wouldn't sue myself. Thank you.
Of course. So it all is going to, the short answer is quoting yourself extensively could potentially be problematic depending on who owns the copyright. So if, for example, if you transferred your right in copyright to the publisher when you allow them to publish your work, that potentially is a problem because somebody else at this point in time might actually own the copyright. So again, that would be something that you would want to look at very carefully, and that's going to also require taking a look at who is in fact the owner of the copyright at this time, and it's all going to depend on what are maybe the contractual obligations that you have with that original publisher when you have that work published. So maybe not, again, a straightforward answer.
All right, hold on a second here. I lost my, here we go. Is the use of a trademark in internet sales considered interstate commerce? Are internet sales considered interstate commerce?
They may or may not be interstate commerce. So the short answer is yes, typically, but that doesn't always work, and services is immediately what comes to mind because there are specific rules associated with services and the use of trademarks on services. So what I would say is the short answer is yes, that typically is interstate commerce, but not always. So if you have a question that's specific to your facts, then the best thing to do is to go ahead and obviously call somebody who's familiar with trademark law or give me a call and we can talk about it further.
Okay. Recorded version, oh, yes. Albert and everyone else that's still on the line, you will receive a recorded version of this along with a PowerPoint presentation. What do I need to consider when changing design of something already patented?
Okay, that's, again, not necessarily an easy question, so I'll try to simplify it as best I can. When we're looking at a patent, the patent actually has, at the very end, it has some numbered paragraphs which we call claims. The claims are the legal protection that define the scope of what the invention is that's protected under federal law. So in order to not infringe a patent, what you want to do is look at what is claimed in the patent and then change the things, that becomes then the template for what needs to be changed. And so long as your product does not incorporate the things which are protected, or so much as, the simple rule is if you can avoid one of the things that is claimed in the patent, that may be enough to avoid infringement. So what you want to do is take a look at what's claimed and then look at your own product. If your product does not include all of the things which are claimed, then that could be one way to avoid infringement, but it's not. It's a very difficult question to answer just very broadly.
Okay. We're going to take one more question and then we're going to wrap it up. So can someone include short scenes from a copyrighted film in a video review of that film?
It's an excellent question, and that goes to the question of fair use. And so what I would say is it may or may not be okay depending on what it is that the review is for. So what I would say is that you really need to look at this a little bit more carefully. But immediately what I was thinking about was if you're doing a review, like, for example, let's say you're doing a review for a class exercise or maybe a thesis or something that you're doing, I would say that that use of the snippets from somebody else's work would more likely than not be fair simply because it's being used in the educational context for the purpose of educating other people. However, if you're going to be selling your product that includes those snippets, then the answer may be different depending on what it is that you've done, and so it's maybe not so much an easy answer.
Great. I think we got to probably 99% of the questions. It looks like most of the ones that are still here were answered throughout the course of this presentation, so we're good to go. For those of you still on the line, I want to thank you for joining us. If you do have a question or need to talk to Jeff directly, his information is at the end of this PowerPoint presentation. If you haven't written it down at this point, don't worry about it. You will get a copy of the PowerPoint and a copy of this presentation, a recorded copy, hopefully within about the next 24 hours. I will leave it at that unless you have any closing thoughts, Jeff.
No, I don't. Just thank you, everybody, for listening.
Thank you, everyone. Have a great day.